Regular session. Mr. Clerk, please call the roll.
Representative Banta.
Present.
Representative Bauman. Representative Blanton.
Present.
Representative Burke. Representative Dietz.
Here.
Representative Flannery. Representative Griffey.
Here.
Representative Kulkarni.
Present.
Representative Lewis.
Here.
Representative Maddox. Representative Marzian. Representative Mosier.
Here.
Representative Nemus.
Here.
Representative Petrie. Representative Roberts.
Here.
Representative Stevenson. Representative Whitaker.
Here.
Representative Williams. Representative Wilson.
Here.
Vice Chair Decker.
Here.
Chair Elliott.
I'm here. And so we do have a quorum present. We're duly constituted to conduct business. Does any member seek to recognize anyone in the audience?
I do, Mr. Chairman.
Representative Nemus.
We have Councilwoman Donna Purvis with us today from Louisville. Would you help me make her feel welcome?
Welcome. Thank you for being here. I met earlier this morning with commissioners from the city of Danville and the mayor of Stanford, so I know it's City Day, so we welcome all of our League of Cities folks who are here. So we have a fairly robust agenda this morning. We have 6 bills for consideration. I'm going to go a little bit out of order from what is listed. The first bill that we will hear is House Bill 446. Representative Kim Holloway, if she would come forward. And if you would please introduce yourself, and I know there is a committee substitute, but I'll let you introduce yourself, and then we'll take up the substitute. So,
sure. My name is Kim Holloway, House District 2.
Thank you. Pull your microphone a little closer. I have that problem too. So there's a motion. There's a second. All those in favor, please say aye. Aye. All those opposed, no. And the sub is adopted, so it is before the committee. So you may proceed.
Chair Elliott and members of the committee, thank you for allowing me to speak on behalf of House Bill 446 today. This bill seeks to amend KRS 508.025 to expand assault third-degree charges to individuals who cause or attempt to cause physical injury to a justice or a judge of the Court of Justice and to public transportation drivers. The goal of this proposal is to provide these public servants with the same protections from assault as social workers, teachers, school bus drivers, and others under current Kentucky law. This bill is the result of concerns by various individuals. I was approached by a judge in my district who had noted that protections from third-degree assault were not extended to acts of violence perpetrated towards judges. The committee substitute that includes public transportation drivers is the result of concerns expressed by the City of Louisville and Louisville law enforcement. This legislation comes on the heels of a surge in acts and threats of violence against judges across our nation. Over half of judges report threats to their safety, and actual acts have risen sharply in the past few years.
So there's a motion and a second. Is there any discussion on House Bill 446? Representative Nemus.
Thank you, Mr. Chairman. Representative Holloway, thank you for bringing
Yes,
this
sir.
bill. It's long overdue.
Yes,
I don't
sir.
know why there was oversight in the beginning. Thank you for fixing that. I would ask you if you would be okay with a floor amendment that would add circuit clerks. My reasoning for that is when I was the director of AOC, I went to a lot of courthouses, and even as a lawyer, I do that as well. And the circuit clerks are the first one you see inside the door. They're the ones who are taking the petitions that are highly emotional. And so I would request that we add the elected circuit clerks to this. But this is a wonderful bill, and I'm happy that you brought it. Thank you.
Thank you. I would be supportive of such an amendment.
Thank you. So there's a motion and a second on the bill as amended. Mr. Clerk, please call the roll.
Representative Banta.
Yes.
Representative Bauman.
Yes.
Representative Blanton.
Aye.
Representative Burke. Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Flannery.
I'd like to explain my yes vote.
Yes, go ahead.
I'm voting yes. think I agree with what Representative Nemes has to say. Perhaps we should include all officers of the court. I don't know if we should pick and choose. I think kind of the intent is to protect those that work in there, so maybe that's something we can do, include any officer of the court. Thank you.
Representative Griffey,
Yes.
Representative Kulkarni,
Yes.
Representative Lewis,
Explain my yes vote.
Yes, go ahead.
Thank you, Mr. Chair. Representative, I appreciate you bringing this bill. My judges reached out to me. I think it's a good piece of legislation, and I applaud you for bringing it forward.
Thank you.
You have my full support. Thank you. Yes.
Representative Maddox,
Yes.
Representative Marzian, Representative Mosher,
Yes.
Representative Nemes,
Yes.
Representative Petrie, Representative Roberts,
Yes.
Representative Stevenson, Representative Whitaker,
May I explain my yes vote?
Yes, you're recognized.
This is a fantastic bill. In my district, we had a horrible incident of courthouse violence this past year. So this is very important to me. We need to keep everybody in the justice system safe and hold those accountable who want to disturb the peace in our courts of justice. So thank you.
Representative Williams, Representative Wilson, Chair Elliott,
Aye. So with 18 yes votes and no votes, House Bill 446 is amended by the committee sub is favorably passed. So congratulations to you.
Thank you. I
Representative
appreciate it.
Holloway.
Thank you.
The next item that we will take up on the agenda is House Bill 456, an act relating to driving under the influence, and that is sponsored by Representative Patrick Flannery, who is a member of the committee. And if you would introduce yourself, Representative Flannery, you don't need an introduction, but we do that here, and any guests that you may have.
Thank you, Mr. Chairman, Vice Chair, and members of the committee. Patrick Flannery, representative for the 96th District. I believe we potentially had someone that was going to join online. I don't know if they're on or not if there's any questions from committee members.
Yes, Mr. Flannery, I am on. Joe Ross, Logan County Attorney and President of the County Attorneys Association.
Good morning. You can proceed.
All right, thank you. This morning I present House Bill 456.
There is a committee substitute, Representative Flannery. There's a motion, a second. All those in favor, please say aye. Aye. Those opposed, no. And the committee sub is adopted.
Thank you. House Bill 456 covers many issues involving DUI law, and in many respects is a cleanup of things that have occurred in the last few years. I'm going to try to very briefly go through section by section of this. KRS 189A.010 is amended to include 3 substances to the per se list. I know last week Representative Blanton had a question about fentanyl. That is a huge topic. So it does include fentanyl to the list of per se. Fentanyl can actually be prescribed to people, usually in very severe pain, often terminally ill. So that does include that because it is a substance, unfortunately, that we see used more often. It also includes, I won't attempt to pronounce it, but it's Flexeril. It's a muscle relaxer that's included to this substance, and Klonopin, which is another substance that comes up quite often. It does establish that operating a motor vehicle with a suspension is an aggravating circumstance. So that is all covered in KRS 189A.010. A couple years ago, I had a bill in response to the McCarthy decision This is a cleanup on that, amends the implied consent statement under Kentucky Revised Statute 189A.105 and requires notice that if a person refuses a blood test, his or her license will be suspended at his or her arraignment and will be suspended if he or she is convicted of a DUI. And then it also has certain cleanup on ignition interlock devices, which I think we started around 5 or 6 years ago. We're starting to kind of get the kinks worked out on that, and it makes some changes on that. I think the highlighted portion, I would say, is that it has a 6-month period if you use it. On first offense, any other person not using it would be a 9-month suspension. And then we see more and more electric vehicles. So when these devices are installed on electric or hybrid vehicles, it is a little more complicated. And there is a change in the installation fee for those vehicles. And I will turn it over to Mr. Ross if he has
a motion on the bill. There's a second. And Mr. Ross, I'll yield to you for any comments that you have.
Well, I would just thank Mr. Flannery, or Representative Flannery, for bringing this. It does do a lot of good things to toughen and clean up DUI laws. The implied consent is a big issue that we've seen since the McCarthy decision, and this will alleviate a lot of DUI prosecutions across the state. I would also say fentanyl being on the per se list, it was so obvious that we didn't notice that it wasn't on there. So again, thanks for putting that on there, and toughens up suspended licenses by extending that interlock period, and then also increasing the punishment when someone does drive without that. So covers a lot of areas, but does a lot of things to safen up our roadways, and happy to answer any questions if you have any.
Thank you, Mr. Ross. And does any member have any seek recognition? Representative Lewis.
I just have a comment on the bill, and I'll work with the sponsor on it. On Section 1, subsection 12, where you're going through clonazepam, cyclobenzaprine, fentanyl, the only thing I'd recommend is maybe we look at classes of drugs instead. Because, I mean, let's say you take Valium, for instance, diazepam. It's oftentimes treated for anxiety, just like Klonopin is. But I'll get with the bill sponsor on that. It's a good piece of legislation. Thank you.
Thank you.
Thank you, Representative Moser. You're recognized.
Thank you, Mr. Chairman. And Representative Lewis's question kind of covered what I wanted to talk about. I think it's rather than having to come back and add a new drug every year or every time somebody comes up with a new controlled substance or some derivative, we should probably address it through classes of drugs. So I'm in favor of this. I just think that any time that you're dealing with a controlled substance and driving, we should, include others possibly.
Yeah,
So,
if I could respond to that, Mr. Chair.
Yep.
Those two suggestions, those are probably not bad ideas. I'm not really sure the history. I know it does start off with any Schedule 1 substance, and then it says except marijuana. So any other schedule, like 2 or 3, it doesn't include, and then it's just kind of a mixed bag of what has been included over the years. But I'd be glad to talk to you all about that and maybe try to find out the history of why it wasn't set up like that in statute previously, and it actually lists. The other problem you get into is some of these chemical substances, they're similar but not always the same, so you can have kind of look-alike drugs that function the same, but it may be technically different than what's actually listed. So perhaps that is a good idea to look at doing this by schedule rather than listing, I guess the chemical name of the drug.
Thank you. Did you have a further comment, Representative Moser? Okay. You were looking back, so I just wanted to make sure.
Yeah, well,
Go
thank
ahead.
you. You more or less clarified what I was going to say. I mean, I think any intoxicant should be included. So, if somebody is, even if somebody's prescribed one of these drugs, if they're misusing it and creating an unsafe situation while they're behind the wheel, it should probably be accounted for. So that's all.
Representative Wilson.
If I may, I just want to make clear that other substances not on the list would still qualify for a DUI under other subsections, just to make sure to clear that up.
Correct. It would be something where you could be prosecuted as a what's called a probable cause DUI, where you prove beyond a reasonable doubt based on other evidence.
So we do have opposition, and that is Mr. Scott West. If you would come forward and introduce yourself, and you don't need an introduction either, but do that for the record, and then you can proceed.
Thank you, Chair Elliott. I am Scott West, and I'm here for the Kentucky Association of Criminal Defense Lawyers. And on the sign-up sheet, you get to pick pro or con. I feel like my testimony is more nuanced than that today, and let me explain why. I was on, as a member of DPA at the time, I was on the 2018 group that really overhauled the ignition interlock legislation. There were over 30 people on that group. You had county attorneys, public defenders, judges, Department of Transportation, I think AOC sent a representative. There was also people from the industry of IID and the bourbon industry. This was part of their give back to the community. They were pushing for stronger ignition interlock laws as well. And one of the issues that we had, especially for a first DUI, is we were persuaded by the industry that even a first DUI needs ignition interlock, because it doesn't just keep you from drinking and driving, it teaches you to drive without drinking. You can't just buy or pay or rent for an IID and not use it. You have to use it periodically and blow into it. You can't just park it. And in this way, it teaches people to drive responsibly. But there's an issue, and I'm learning this even more as a private practitioner. The first thing a client will say is, how long do I have to be on it, and how much is it going to cost? Under the current bill, I can tell them the answer. I can say it's $100 hookup, it's $100 a month, it's 4 months if you do everything right, 6 months top for a first DUI, $700. As long as you don't blow into it and lock it up and have to get that fixed at $50, as long as you don't miss an appointment and have to pay a late fee of $35, that's how much it's going to be. Under the under the bill, I'm not going to be able to tell my client how long they're going to be on it for sure. The 90-day window or the 120-day window, depending on what number DUI it is, can go on in perpetuity. If you commit a violation, it resets your clock, and you have to go, even if you're at the end of the suspension, you have to go on even further. Now, the problem is violation doesn't mean like speeding. It doesn't mean like picking up some other violation of the law. There are 6 enumerated ways you can violate that's going to reset the 90-day clock or the 120-day clock. Some of them would be on the driver. If you hide your face from the camera so that they can't see who's blowing in, that's on you. If you blow above a .02 and lock it up, that's on you. If you don't pull over and blow when you're supposed to, that's on you. But there are 2 of them that concern me. One is if you fail to make an appointment for maintenance, repair, calibration, monitoring, inspection, or replacement. That could be difficult because you're not in control of that. Let me give an example. I'm from Martin County. The closest vendor that you can get one of these, if you get a DUI in Martin County, is 18 miles from mine is. And if you are on the western or the eastern part of Martin County, you're 28 miles away from the closest one. If you're a coal miner and you're driving to work every day and you get the notice that says we need to calibrate or we need to replace your model, you know, that's the kind of thing that if you miss it, and it doesn't say unexcused failure to make your appointment, it just says failure to make the appointment. That's the type of thing that can reset your clock again into perpetuity. And the other thing is the fee. If you fail to pay your fee, and we're in an economy where your job is not secure, if you fail to pay your fee, that's going to add 90 or 120 days to the end of your suspension. So if you can't pay for it now, the remedy is going to be we're going to give you more that you can't pay for. And so I have those concerns. What all this will mean is you're going to see an increase in people opting out of IID altogether. And that's not the goal. The goal is to get people to opt in, not make it prohibitively expensive to where they will opt out. People need to know what the cap is going to be if they go IID. And if you say, well, it can go on and on and on until you get that 120 days, I see a lot of people not taking that risk. The other thing I'd like to talk about is the tolling of the suspension, and I understand why that's in there. The tolling, there's pretrial suspension, and tolling doesn't really work with pretrial suspension because let's say you get an aggravated DUI and you get a pretrial license suspension, and you would negotiate it for 4 months, and then you end up pleading and you go to jail for 4 months. Well, you don't get your license back for those 4 months you're in jail. And if it's tolled until you get out of jail, well, then that doesn't just toll it, that adds time to the statutory cap. So I would like to see that worked out so that it doesn't go beyond the statutory limits for the amount of time that you could be penalized. I have talked to one of the industry representatives. They are willing to work on some of the things to keep it an incentive. Back in 2018, we were really concerned about making sure that people didn't walk away from IID on a first DUI. And what we came up with was what the group decided was probably the thing that would do that. If we're going to expand that, it may come at the cost of people not participating in IID. And that's not what we want. We want people using it. Thank you.
Thank you, Mr. West. Is there any response, Representative Flannery or Tim?
Yeah, very briefly, I would agree with some of the statements made. It's been my experience that there are some geographical burdens sometimes with the vendors, the installers of these devices. I don't know how we change that. I guess my response would be that when when a person is charged with this, they choose whether or not they want to use this device. It's not mandatory, so that's something they choose to use. And if there's sometimes there can be glitches and problems with these devices, and I think if they need to be fixed, they need to be fixed. And if there's not fees paid and things like that, then there have to be consequences for not holding up that end of the bargain. So if it was mandated, I would probably be much more sympathetic to the argument that was made. But this is something that when a person's charged, they choose to use this, and I really don't think that it's going to have a chilling effect on people utilizing these, because some of these changes that have been made, it's actually going to I actually think will encourage more people to try to utilize these devices based upon the suspension period.
I would just say I've been on the board at various times for the county attorneys since 2016, and I believe I might have participated in the group that Mr. West was talking about, and I know I participated on another one a few years ago when we made some amendments and took the oversight of these away from the county attorneys and put that with the Department of Transportation. I would say since that period of time, I haven't seen quite as many technical violations. I think the program is working well. If there were cleanups that needed to happen in the future, I would defer to the language with the interlock folks that would understand what way to maybe talk about differentiating between a significant violation and a minor violation. But I'm like Representative Flannery, I don't believe that will be an issue. I've seen this actually be a benefit because it does allow people to start driving immediately where the old system didn't. And the moving of the suspension time up to the 6 to 9, I believe that was the national standard at the original time we did this. So we would kind of just be coming up to what was requested back then. So I do believe in the end this will be a good thing, with possibly some things to clean up, but I think it's better for all ultimately at the end of the day, in terms, especially those people sharing the roadway with these drivers.
Thank you. So there's a motion and a second. Mr. Clerk, please call the roll.
Representative Banta,
Yes.
Representative Bauman,
Aye.
Representative Blanton,
Aye.
Representative Burke, Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Flannery,
Yes.
Representative Griffey,
Aye.
Representative Kulkarni, Representative Lewis,
Yes.
Representative Maddox,
Pass.
Representative Marzian, Representative Moser,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Roberts,
Yes.
Representative Stevenson, Representative Whitaker,
Yes.
Representative Williams, Representative Wilson, Chair Elliott.
Aye. So with 16 yes votes, no votes, and 1 pass vote, House Bill 456 is amended, does favorably pass. So congratulations, Representative Flannery.
Thank you, Mr. Chairman and members of the committee.
The next bill for consideration is House Bill 10, an act relating to the rights of real property owners. Representative Mary Ann Proctor, if you would come forward. And you have several, and also Representative Emily Callaway's with you, and if each of you would introduce yourselves, and then your guests can introduce themselves, and then you can proceed.
Thank you, Mr. Chairman. I am Mary Ann Proctor. I represent the 60th District in Boone County.
Thank you, Mr. Chairman. Emily Callaway, and I do represent the 37th District.
Colleen Lindgren, Legal Policy Manager for Pacific Legal Foundation.
Sorry. Major Tom Zerlinski with the Boone County Sheriff's Office. I'm their staff attorney.
Thank you, Mr. Chair and the committee today. I'm excited to bring to you House Bill 10. This has been a collaborative effort that I'm proud to work with my colleague, Representative Callaway, and certainly the people at this table. They have been instrumental to crafting a really good piece of legislation that is supported by a lot of associations like our Kentucky Sheriff's Association, our realtors. So what this bill is doing, many of you may be aware of that squatters are becoming a problem in the United States, and the Commonwealth is not exempt. So what this bill is doing is defining what a squatter is, and it streamlines what law enforcement is able to do to be able to remove them. So this bill's got multiple parts to it, so I'm going to have Representative Callaway speak on that for the next part.
Thank you, and I'd like to echo that gratitude to leadership that's been instrumental in making sure this is the best bill, which I believe we have. So what I saw in my district was essentially twofold. We needed property owners to be protected by an expeditious removal of a trespasser, and we needed our law enforcement officers to be protected. They shouldn't have to be the judge, jury, and executioner on the spot deciding whose word to believe. So there's a portion of the bill that will address that, and what that does is create a petition that the assumed owner would fill out, and this petition will be provided by the responding officer and is created by the Department of the State Police, and that will state that he or she is the owner, and then that document becomes a sworn declaration. So that officer actually has something tangible to create the case. And it'll protect that officer as he's carrying out this, again, the requested removal promptly, keyword. I want to reiterate that this does not apply to tenants, current or past. It does not cover family members or of the property owner, and does not apply, and applies to all real property. So I'll get it together. All real property. So we're talking if it's an individual's house, if it's land, if it's a commercial property, if it's a barn. We've covered everything in this with real property. And as the officer, I do want to reiterate again, as the officer is removing this individual, whatever, they'll determine whatever charges are appropriate and follow suit, whatever that looks like. Meet the individual, the trespasser, as need be. And that's the segue into another portion. So I will defer to Major Thomas Serlinski.
Thank you, Mr. Chair and committee. The current status right now when it comes to squatters from a law enforcement standpoint is kind of ambiguous. There are some folks that believe it's actually just straight out criminal trespass. However, there's an argument that tenancy rights may have been created. So I think what this bill does is by defining what a squatter is and laying out the procedure to address that, it gives that law enforcement officer, especially at 2 o'clock in the morning when a lot of these calls come in, some very clear guidelines on how to deal with this incident when it comes up. What it does is it gives the officer the ability to address it, but doesn't mandate that with an arrest. It allows that officer to discuss it with this person, whether that person is there mistakenly or whether it's an intentional act. But it allows that officer some discretion to, hey, please, you need to leave. The homeowner's telling you need to leave. Or if they refuse to, then it allows them to make an arrest for a misdemeanor offense. The twofold from my perspective as a law enforcement officer is one, that it gives some very clear guidance for those law enforcement officers. And two, what I think it does also is it's a preventative measure, and maybe by adopting this statute, we can prevent some of this from happening even before it becomes that traumatic for that property owner. As part of the bill, we also included currently in the statutes under KRS 512 with damage to property that any damage by a squatter would be treated the same way that damage is treated by a tenant. So it allows that tenant to also, that property owner to also address any damage that would occur to their property. Thank you.
So just in summary, what it does is allows us to quickly remove somebody without the expensive legal process and the months and months it takes to evict the squatter. And it also provides protection for our law enforcement when they are acting in good faith, that they are not held criminally or civil liability. So we put those protections in there. And also, if somebody is removed that's wrongful, that they are not a squatter, there's also protections for them as well.
And second, is there any discussion? Seeing none, Mr. Clerk, please. Okay, Representative Nemus, I'm sorry.
Thank you. I noticed, thank you guys for working together, ladies for working together. I think you had two bills that were good, and the combination bill, if I might say, is very good bill. Look forward to supporting it. This is an issue that we have to address. I'm glad we're doing that. I would, if I could, refer you to page 4 of the bill, lines 12 to 15. It seems to me, I think we're talking about here, so if the landlord removes the squatter or the purported squatter and they've done it wrongfully, and this, I think, is holding that landlord, giving them immunity. I don't think they should get immunity, because under this circumstance, my understanding would be the person they've removed wrongfully. And so if they bring some kind of claim against them, they should be able to recover for that. They should not get immunity, because the landlord knows that they're acting wrongfully under this circumstance. So I'd like to talk more about that with you after the committee. I do not support immunity, because that would have been a wrongful actor. So anyway, we'll talk more about that, but I think this is an issue that needs to be addressed. Thank you, guys. Thank you, ladies, for working together so well to get it done. Thank you, Mr. Chairman.
If I can address that.
You want to respond to that?
Just quickly.
The end of the paragraph seems to say, unless the removal is found to be wrongful. So there is a stipulation.
Right. So the intention there is if while removing the individual's property, they unintentionally damage some goods, we don't want them to be held liable for something like that.
But if it's wrongful.
But if it was a wrongful
removal,
removal,
if I'm acting
absolutely.
wrongful, then I would have liability.
That's right.
Okay.
Right.
Thank you.
Thank you.
Okay. Thank you. Any other comment, question, discussion? Mr. Clerk, please call the roll.
Representative Banta?
Yes.
Representative Baumann?
Yes.
Representative Blanton?
Aye.
Representative Burke? Representative Decker?
Yes.
Representative Dietz?
Yes.
Representative Flannery,
Yes.
Representative Griffey,
Yes.
Representative Kulkarni, Representative Lewis,
Yes.
Representative Maddox,
Mr. Chairman, may I briefly explain my vote?
Yes, you may.
I'm voting yes today, and I'm just very grateful for all of the efforts that you've put in, especially you, Representative Proctor. This has been a long time coming, so thank you.
Representative Marzian, Representative Moser,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Roberts,
Briefly explain my vote, Mr. Chairman.
Yes, you may.
I am an enthusiastic yes on this bill. I've handled evictions in my legal practice, and I can tell you it is easier to evict a rightful tenant than it is to evict a squatter right now under Kentucky law. It takes months. You have difficulty even identifying who this unlawful occupant is. It should not be easier to evict a lawful tenant than it is to evict someone who had no permission to be there in the first place. So for that reason, I'm an enthusiastic yes on this bill.
Representative Stevenson, Representative Whitaker,
Yes.
Representative Williams,
Yes.
Representative Wilson, Chair Elliott.
Aye. So with 18 yes votes and no votes, House Bill 10 does pass with favorable expression. Congratulations.
Thank you, Mr. Chair and
Proctor.
committee.
Before we move on to the next item, I'm going to recognize Representative Roberts to introduce some guests.
Thank you, Mr. Chairman. I wanted to give a shout out to the members of the Boone County Sheriff's Department who are here right now. We are joined by Colonel Les Hill and Major Tom Zerlinski of the Boone County Sheriff's Office. Just wanted to make them feel welcome.
Thank you for being here. The next item we will hear is House Bill 96, an act relating to coercive control. Representative Stephanie Dietz, who is a member of the committee. Good morning. If you would introduce yourselves, and then there's a substitute that we will take up, but if you would introduce yourselves for the record.
Yes. Good morning, Chair and members of the committee. Stephanie Dietz, represent the 65th District.
Christy Birch, the CEO of the Ion Center from Northern Kentucky.
Good morning. Is there a motion to, there's a motion and a second. All those in favor, please say aye. Aye. Those opposed, no, and the sub is adopted.
Okay, thank you. Thank you for the opportunity today to speak in support of House Bill 96. And I do want to give my sincere thanks to all the members that spent time working on this bill. I know Representative Roberts spent a great deal of time looking at this bill, as did Representative Nemus, as well as others. I hope that I was able to address those concerns in the committee sub, but I do appreciate the time that each and every one of you gave to hopefully make this a better bill. What is coercive control? Coercive control is a pattern of behavior that is used by an abuser to dominate their partner through intimidation, isolation, and psychological manipulation. Unlike physical violence, which is often easier to identify, coercive control operates in the shadows. It restricts a victim's independence, their financial resources, communication, and even their daily movements. It can include threats, humiliation, surveillance, gaslighting, and controlling access to basic needs. The result is a victim who feels trapped, powerless, and unable to escape. While coercive control may not leave a visible bruise, its impact is just as devastating. It leads to a severe emotional trauma, financial ruin, and in many cases, an escalation to physical violence. Why is adding coercive control to Kentucky's domestic violence law important? Kentucky has one of the highest rates of domestic violence in the nation. According to the National Coalition Against Domestic Violence, Kentucky ranks 5th in the United States for the rate of women killed by men. Nearly 40% of Kentucky women and 32% of men experience intimate partner violence in their lifetime. And yet our laws fail to account for the full spectrum of abuse that victims endure. Under current law, many survivors of coercive control have little to no legal recourse until physical violence occurs. By then, it may be too late. Adding coercive control to our domestic violence statute will protect victims before abuse turns physical, closes some legal loopholes that allow abusers to control their victims without consequence, strengthens our protective orders by recognizing the full extent of domestic violence, and encourages early intervention by law enforcement and social services, preventing further escalation. Kentucky has made progress in addressing domestic violence, but our current legal framework is outdated. When it comes to recognizing the psychological and non-physical tactics of abusers, survivors should not have to wait for bruises before they are believed and protected. And with that, I'm going to turn this over to Ms. Birch.
Thank you so much, Representative Dietz. Thank you, Chairman Elliott. Let me move this closer. Every day at Ion Center, we work to take the best care of people who've been impacted by intimate partner violence, sexual violence, and stalking. And for 27 years, I've been doing this work and seeing the horrible atrocities that survivors of violence face on a daily basis. And when we look at what's at the root of that, it's all about coercive control, because it's a pattern of behavior that impacts someone's everyday life, every aspect of their life. It's not about somebody giving away their power. It's about someone stripping away another person's free will and liberty. Currently, our protective order laws have to have physical violence has had to have happened imminently, as well as like they're not qualified if they don't get it, if they don't have violence happening yet. So everyday survivors are feeling real fear, feeling fear of violence, and it's because of coercive control. It's all about controlling finances and bills, repeated harassing calls and texts at the workplace. It's isolating somebody from their source of support, family, friends, any kind of community resource. It's extreme jealousy, accusing somebody of multiple affairs. It's about monitoring somebody's whereabouts. It's about tracking devices. It's about not allowing someone to make decisions. But really why I'm here is to talk about what I see every single day. And we had a family that came to us that never experienced physical violence, yet coercive control was part of every single day of their life. The kids were never allowed to play outside. The kids were not allowed to mom was not allowed to potty train the kids. They were withheld food, shampoo, soap, and the kids had never been to school. When they escaped to our shelter for the first time, that's when they went to school, and the oldest child was 12. Every aspect of their life was controlled. There was another client that we worked with who we would consider in the upper socioeconomic stratus, and she did not have any access to any money whatsoever, and it was time for her kids to go to school, and she needed uniforms for the kids, and she had no access to money, so she got a store credit card. And when that bill came due, he refused to pay it, turned her into credit. Her credit got turned in, and it made it almost impossible for her to leave. Lastly, I'll share a survivor that sticks with me almost every day that I do this work. She had one violent attack in her life, yet she lived in constant fear. Years ago, she was beaten with a metal pipe that they kept under the sink. He didn't have to hurt her anymore. All he had to do was point to that metal pipe and that sink, and that was enough to keep her afraid and to keep her in that home. So that gesture of pointing to that sink, she was almost beat to death, epitomizes coercive control and why it is so needed, why we need this protection.
The motion and a second. Thank you very much. Is there any discussion on the bill, and I'll recognize Representative Maddox.
Thank you, Mr. Chair. I have a question under Section 1, letter C, where it says carrying, exhibiting, displaying, drawing, or threatening to use any firearm. And then it says at a time and place that manifests an intent to intimidate. I'm just wondering under which circumstances people are going to be prohibited from carrying a firearm having not committed a crime. What are those circumstances and what are those times and places and what does that look like? Thank you.
I think the key with this piece of legislation is that this is a pattern of behavior. So it's not a one-off. And it's not a person that's coming in, if they're a police officer or they're carrying a weapon for the purpose of their job, or if they just carry. I don't think it's a one-off. It's a pattern of behavior, and that's what I see in my law practice. I think that's what Christy Birch is seeing. And I think that I like the question because I wanted to address some of the concerns I've heard is how do we keep this from being abused and aren't we going to have more hearings? I think it ought to be harder to get this type of an emergency protective order. And keep in mind, this is an ex parte motion. When you go to the courthouse, you are filling out this form. And I have a copy of it. I'm happy to share. You can get it off the AOC website. It's good if the judge signs it, it's good for 14 days before you have a full hearing. The judge can deny this. If the judge doesn't see that there's a pattern of behavior, we're leaving that up to our judge. So I don't think it's a one-off. I don't know if that answered your question, but I certainly did not write this with the intent that they're carrying a weapon or a firearm, whatever it is, and it's a one-off. It really needs to be part of a pattern of behavior.
Follow up, Mr. Chairman.
Yes, you may.
I appreciate your response, and I appreciate the thought that you've put into it. But essentially, if we pass this bill, we're going to create a situation where someone hasn't committed a crime, and they could be brought into question by virtue of simply carrying a firearm, not brandishing a firearm, not making a threat with the firearm, but just carrying a firearm. And to me, that's problematic. But I do appreciate your response.
Okay, thank you.
Any other member seeking recognition? Representative Roberts.
Representative Dietz, thank you for working with me on this committee sub. Wasn't the term for carrying a firearm removed and it now has to be threatening to use or actually using a weapon? I just wanted to clarify on that. Or is there something about carrying a firearm in this?
I don't have the committee sub in front of me. I left it there. So I believe that was supposed to be changed in the committee sub.
It looks like it was Section C that Representative Maddox was referencing, so that's been changed to threatening to use any weapon that appears capable of producing bodily harm in a manner, under circumstances, and at a time and place that manifests an intent to intimidate the other person or the other person's domestic animals.
Thank you.
So that's the new language that changed what you referenced. Yes.
With the time and place, I mean, is that something, can you help us understand that a little bit better?
Yeah, I think I envision that again as part of that pattern, the isolation. So usually what happens with coercive control, I had a client, she used the word silo. Mm-hmm. So they begin to silo your life away. They'll take away your finances. They'll take away your vehicle. They'll take away your friends and your family. So what I would see then is that could happen within the home. It could happen when you're out in public and you're at a children's event. I had that occur at a kid's basketball game, and they carried and just they were able just to pull their jacket back. It's an attempt to control behavior. So I hope that answered your question on that. Again, I really want to focus on that this is a pattern of behavior. It's not just one time. I would have concerns if a judge signed an EPO based on that. Although under the current statute, I would think if they act like that, it's a threat of violence, which is how our statute reads now. So I could see where a judge, even under our current statute, could sign an EPO based on that behavior.
Lifting their jacket would be a threat of violence?
Depending on the circumstances, I think depending what else they wrote in the EPO, I could see where a judge could possibly enter an EPO based on that act.
Thank you.
Thank you. I have a question. I know we've had discussions about this bill, and I have no doubt that coercive control occurs throughout our state, and predominantly, I think, men against women. Men are doing it to women. I think the statistics show that. My question is just more of a structure of the bill. And you and I have had this conversation, Representative Dietz. Why do you think it's important, to define it to the extent that you have beyond just paragraph A, which I think gives us a really good idea of what it is, and it has to be a pattern of conduct. What is important about the definitional language that you have in the bill? And I know that's been important to you, and so I just want you to talk about that a little bit with the committee.
Sure. We heard this bill during the interim, and the comments that I heard in the interim, specifically from Representative Nemes, is he wanted it to be more specific. I believe that Representative Flannery may have made a similar comment in the interim. I worked on that in the interim, and that is why we had those specific, we looked at other states that have done this, and that's where we pulled that from. Just on Friday, and I don't believe in coincidences, on Friday, the Court of Appeals released a decision that I circulated in, I think it's Hogle versus Hogle, and they specifically upheld Judge Rolfe's decision in an EPO DVO case out of Kenton County, and he used a pattern. There was an actual physical act of violence. She didn't report it for quite some time, but he went on and he heard the testimony, and it was a pattern of behavior, and he used the word coercive control. And the appellant tried to use that as the legislature not defining coercive control as a reason why the DVO should be overturned. The Court of Appeals upheld the decision of our family court judge. But I think this came out on Friday afternoon. I felt like it was very timely that it came out, and I think that we need to define this word that our courts are using. And it is something I feel passionate about. I've seen it in my practice. And what my hope is that we're going to save lives on the front end, and that they don't have to wait to get an EPO so that they can leave. And again, for people that don't practice, this is a ex parte temporary order until you get in front of a judge. Shouldn't be more than 14 days. And once you get there, then you have a full hearing. The judge at that time, I've had them dismissed. So I think that all we're doing is we're giving the judges another tool to save lives.
Thank you very much. Any other member seeking recognition? If not, we've had a motion and a second on the bill as amended. And Mr. Clerk, please call the roll.
Representative Banta?
Yes.
Representative Baumann? Aye. Representative Blanton?
Aye.
Representative Burke? Representative Decker?
Yes.
Representative Dietz?
Yes.
Representative Flannery?
Yes.
Representative Griffey? Yes. Representative Kulkarni? Representative Lewis?
Yes.
Representative Maddox?
No.
Representative Marzian? Yes. Representative Moser?
Yes.
Representative Nemes?
Could I briefly explain?
Yes, you may.
Thank you. I want to appreciate Mrs. Dietz and the advocates for bringing this bill. You worked very hard on it. I will note that the extra materials that Representative Dietz put into the bill was, at a number of our requests, certainly mine, because I wanted to tighten it up. I have great respect for Ms. Dietz, which is why I'm voting yes. I will note that I've sent this to a number of lawyers and judges, all with significant concerns about how it's going to broaden the opportunity for false claims. And that is real, even though it is just a few weeks, because some people lose their jobs if they get EPOs against them. I could think of police officers, corrections officers, and the like, so we have to get it right. It's not as simple as just saying it's a temporary thing. But out of respect for Ms. Dietz, she's forgotten more about family law than I'll ever know. I'm going to vote yes in committee, but continue to think about it and cogitate on it. Thank you, Mr. Chairman. I'm a yes.
Representative Petrie? Representative Roberts?
Explain my vote, Mr. Chairman.
Yes, please.
So I'm extraordinarily thankful for the work that has gone into this committee substitute. I will say the original draft, I think, would run into facial constitutional issues. I'm not here to say that the risk for abuse of this statute is out of the question, but that said, it has been extraordinarily narrowed. Goes into true threats rather than speech. Specifically mentions threatening to utilize weapons rather than just specifically single out a specific instrument, and getting rid of the carriage language, and also adding the specific intent requirement. On top of the pattern of it, I'm voting yes to advance it to the floor. I understand there are concerns, but for now, I think that this has saved it from a federal court challenge. So thank you for the work on this substitute.
Representative Stevenson?
Quickly explain my vote.
Yes, you may.
I vote yes, and I appreciate the heart and the passion you have for women who can't help themselves.
Representative Whitaker?
Yes.
Representative Williams?
Yes.
Representative Wilson? Yes. Chair Elliott?
I'm voting aye in the committee, and I may change my vote on the floor. So with 17 yes votes, 1 no vote, and no pass votes, House Bill 96 is favorably reported. So congratulations, Representative Dietz.
Thank you, Chair and members of the committee. Thank you all.
Representative Williams, would you like to record some votes? You're recognized to, if you would use your microphone, you're recognized to do that. House Bill 456.
Yes.
And House Bill 446.
Yes, please.
So you're duly recorded.
Thank you.
With those votes. The next bill that we will hear is House Bill 399, and that's Representative John Blanton, who's a member of the committee, an act relating to interference with a legislative proceeding.
Mr. Chairman, I got a motion on the committee sub.
There's a motion and a second. All those in favor, please say aye.
Aye.
Aye. Those opposed, no. And the committee sub is adopted. And if you would introduce yourself, Representative Blanton, and then you can proceed. Thank you.
Thank you, Mr. Chairman, members of the committee. Representative John Blanton of the 92nd District. I come to you today to present House Bill 399. It's not a new piece of legislation to this committee. We passed it out of this committee and out of the House last session. The purpose in House Bill 399 is to ensure that the General Assembly has an opportunity to legislate without interference from people who wish to prevent us from doing our work on behalf of our constituents. Most of you may recall 2 years ago the interruptions that occurred during our legislative process. And one of the most disturbing things to me is this, that occurred that day. There's nothing wrong with protesting, attempting to make your voice heard. It's as American as baseball and apple pie. And I support the right to do that. We should all have the right to have our voices heard. But we can also cross that line. So what I observed that day in the gallery was each one of us represents 45,000 plus or minus individuals within our districts. We are their voices here in the General Assembly, and we have a right to be heard. That day, if you were on the floor, if you recall, the decorum got so bad, out of control, that literally we had to stop the process, call for a vote, and vote. Some of you may have been wanting to speak that day, and you didn't get the chance to because of the interruptions. That wasn't fair to your 45,000 constituents. Now, those individuals were removed from the gallery that day. There was a charge placed upon them. All of those individuals have either pled guilty or were convicted. Now, the question was that the proper charge? Was there a proper charge for that? One could say we could charge this, maybe that. So this lays out a particular charge. God forbid that ever happen again. I don't want that to happen. But if it were to, there is a very clear and defined charge for that.
There's a motion and a second. And I presume you probably want to stop, Representative.
I do, but I will point out I'm working with members right now for some clarification on some things on right to assembly, and I want to make sure people have the right to have their voices heard. I do. I want to protect that right. I just want to make sure that we have the right as the General Assembly to conduct the business that we're sent here to conduct on behalf of our constituents. Thank you.
And I do too. I agree with you completely. Is there any member that seeks recognition to discuss? Okay, seeing none. Mr. Clerk, please call the roll.
Representative Banta?
Yes.
Representative Bauman?
Yes.
Representative Blanton?
Aye.
Representative Burke? Representative Decker?
Yes.
Representative Dietz? Representative Flannery?
Yes.
Representative Griffey?
Yes.
Representative Kulkarni? Representative Lewis?
Yes.
Representative Maddox?
No.
Representative Marzian? Representative Moser?
Yes.
Representative Nemus?
Yes.
Representative Petrie? Representative Roberts?
Explain my vote, Mr. Chairman.
Yes, please.
So when I read legislation, the first question that I ask myself is it constitutional? Right now, this is well-intended legislation. My problem is that in First Amendment law, overbreadth is enough to where even if this is applied in a constitutional manner, the face of the statute can still be struck down. I'm concerned at the moment that there is not enough adequate protections for traditional public forums, and I'm also concerned for our law enforcement community with the shall requirement, where that could ultimately lead to a requirement that they make an arrest even though they have a federal duty to make their own independent determination of probable cause. So I'm a no for the time being, but I reserve my right to change my vote to a yes in the event that language change is made, to just narrow the bill to ensure that our law enforcement is protected and that the statute can survive constitutional muster on its face.
Representative Stevenson?
Yes, please explain my vote.
Yes, you may. You're recognized.
I'm voting no because I have grave concerns about the right for people to assemble. Everything we do is based on that. We were able to conduct business that day. It was a horrible day, but we were able to conduct business. And the moment we start taking people's rights away because we were inconvenienced is problematic. So I would vote no.
Representative Whitaker?
Yes.
Representative Williams?
Yes.
Representative Wilson? Chair Elliott?
Aye. So with 13 yes votes, 4 no votes, and no pass votes, House Bill 399, as amended, does pass. Congratulations.
Thank you, Mr. Chairman. Thank you to members of the committee.
So the last item on the agenda is House Bill 465, an act relating to motor vehicle racing, and the sponsor of that is Representative Beverly Chester Burton. And if she would come forward, introduce yourself for the record, and I know you also have some guests, and they can join you at whenever you want them to do that. Representative Burton, Chester Burton. And before you get started, I know yesterday when we had our discussion on the floor, I told you that you're sitting in the same seat that I had to sit in when I was sworn in to the House in 2016. So that's a good place to sit, I think. But please introduce yourself and then proceed for the record.
Thank you, Mr. Chair and the committee. I'm Beverly Chester Burton, representing District 44 out of Jefferson County in Shively.
If you pull your microphone a little closer, that would be terrific.
Thank you. Introduce yourself.
Jason Nemus, it's 33rd District, Jefferson, Oldham, Shelby Counties.
I think we know who you are. I think we do. There is a sub and there's a motion. Is there a second? All those in favor, please say aye.
No,
Aye.
they're
Those
gonna
opposed,
vote
no, and the sub is adopted.
Okay. I believe there's a PowerPoint that he's.
Is there a PowerPoint?
Yes. Again, thank you, Mr. Chair.
Thank you.
House Bill 465 is presented today as an effort in order to address the issue of street racing, where it's been significantly, significantly affected to my area in Jefferson County. However, I have had other members throughout the community that has also contacted me regarding street racing. And I appreciate Representative Jason Nemes here with me today to discuss this particular issue. I also have with me today Metro Council Donna Purvis, who will speak later. And I will say that this bill has also been approved by the Kentucky League of Cities as well. What this bill simply does really is change the fines, where it goes from 200 to 1,000. And then the second offense, where it raises the fine up to 2,000. But the difference with the second offense is that the car would be forfeited to the state for crushing or auction and the money will then go to the victims. And one of the areas that we looked at is the Crime Victim Compensation Board. And so with that, I also want to provide some statistics, Kentucky statistics of the different fatalities, which was 30% from 2013 to 2023, which was higher than the national average since 2009. In 2023, we saw the most tragic deaths, which was 828, resulting from car accidents since 2016. How is racing involved? The National Highway Traffic Safety Administration reports the amount of deaths from speeding-related accidents increased by 21%. And in 2022, Louisville Metro Council increased straight racing fines and impoundments. And basically what I did, I took a look at the ordinance from Louisville Metro and just modified it in order so that it could be a state law across Kentucky. And then with that, I'll have Mr. Representative Nemes to make his comment.
Thank you. I'll just be really quick. We're bringing this. I understand this is a increase that's substantial. I would note that it just outlaws street racing on highways. Right now, the offense is up to $200. That doesn't properly put into perspective what we're talking about here. These are people who are deliberately putting citizens' lives in danger. They know that they're doing it, and so the first time we're only going to fine them $1,000. I think it should be much higher than that, but that's what we put it for the first offense. The second offense is where it amps up considerably. I know some people are uncomfortable with that. We feel like that's appropriate. If there's discussions that need to be had after committee, I know the sponsor and I are certainly willing to have those conversations, but please help us move this situation forward and protect our people. It is getting out of control in Jefferson County, certainly, maybe in your counties as well, but in Jefferson County where people are racing on the streets, where our babies and our loved ones and our citizens are there just to live their daily lives. So help us, if you could, solve this problem.
Thank you, and I understand that Representative Blanton, you have a question of the presenters. You're recognized.
Thank you, Mr. Chairman. I have a couple questions, if I may.
Go ahead.
Appreciate you bringing this bill. I understand it's an issue there for you guys in Louisville, and we need to try to help you address that issue, and I'm supportive of the bill. But I do want to make sure that we don't inadvertently prevent the tourism aspect that's going on in southeast Kentucky, where we're doing permitted road racing. There are ones that's permitted, and there are professionals that's coming in. I just want to make sure this doesn't impact that.
And I was Representative Blanton, that's a great question. I was reviewing the statute last night, and I believe there is an exception for
That's right.
racing. Is that right?
Yes,
It's
thank
permitted.
you. And Representative Blanton, thank you for the question. The statute that is affected is 189 KRS 189-505, and it outlaws street racing, and then it says except racing events permitted under KRS 189-503. So that would specifically be allowed.
Okay.
We're talking about illegal activity.
Very good. That satisfies. I just wanted to get clarification. Thank you, Mr. Chairman.
Thank you, Representative Blanton. And we do have Metro Councilwoman Donna Purvis. And if you would like to come forward and make a statement, I'm prepared to allow you to do that. So please come forward.
Good morning.
Good
Thank
morning.
you to Mr. Chair and the committee for giving me an opportunity to speak this morning regarding House Bill 465. And I just want to talk about why I support this legislation. This behavior has become a nuisance to the innocent bystanders who are captive by the desire of those who do not regard public safety. These events can lead to dangerous outcomes, violating traffic laws that were created to protect all citizens. I've spoken with several of my constituents who have been impacted by these events of taking over streets, outnumbering law enforcement, and potentially preventing fire and emergency vehicles from getting to homes to render needed attention. These people have reached out to me and are very fearful of what they have seen, stopping short of accompanying me today because of the violence involved in these events, and oftentimes have witnessed the presence of weapons, making them afraid to speak out. It has also interfered with innocent motorists whose route to get to their homes, a safe place, is halted because of the selfish act of taking over streets for drag racing. I am sure this is not just a Louisville problem, and for that reason, a message should be sent to the entire state that this will not be tolerated and they will face serious consequences for endangering others' lives. Thank you.
There's a motion and there is a second, and I agree with you. I think we do need to send a strong message on this issue. I lived in Jefferson County for 7 years once upon a time, and that wasn't an issue then, so I'm sorry to hear that it is now. But we're ready to act and ready to move forward. So there is a motion and a second on the bill as amended. Mr. Clerk, please call the roll.
Representative Banta?
Yes.
Representative Bauman?
Yes.
Representative Blanton?
Aye.
Representative Burke? Representative Decker?
Yes.
Representative Dietz?
Yes.
Representative Flannery?
Yes.
Representative Griffey?
Yes.
Representative Kulkarni? Representative Lewis? Representative Maddox?
Yes.
Representative Marzian?
Briefly explain my vote.
Yes, you may.
Thank you all for bringing this bill. It is so important, and it's heartbreaking to see what happens with the devastation and the deaths of people. And it's going to be out in the state before we know it, so thank you. Yes.
Representative Moser?
Yes.
Representative Nemus?
Yes.
Representative Petrie? Representative Roberts?
Briefly explain my vote.
Yes, you may.
So I appreciate the motivation behind this bill. My concern right now is that we do not have, right now that this provision has a maximum fine of $2,000 for a second offense, and vehicles tend to be worth significantly more than $2,000. In 2019, the United States Supreme Court unanimously held a forfeiture of a vehicle in a felony case where the maximum penalty was $10,000 to be unconstitutional under the Eighth Amendment excessive fines clause. Justice Ginsburg, Justice Gorsuch, Justice Thomas all opined on the disproportionate value of the vehicle compared to what the fine was. And I do have constitutional concerns and would like to research this further. So for that reason, I'm a pass, but I reserve my right to change my vote on the floor.
Representative Stevenson?
Yes.
Representative Whitaker,
Yes.
Representative Williams, Representative Wilson, Chair Elliott.
Aye.
Thank you. Thank you.
Thank you very much. So with 15 yes votes and no votes and 1 pass vote, House Bill 465 as amended is passed with favorable expression. Congratulations.
Thank you, Mr. Chair and Committee,
Thank you.
for your support.
Thank you. If there is no other business to come before